Good morning and warm welcome to us at GP Infonet and today's webinar, which will be held in English. The subject is how GDPR has impacted American companies and the future of transatlantic data transfers. Complicated words. And these areas, GDPR and everything related to it, seems to be an area where the more you learn, the more you hear, the more questions you have. And I think that almost everyone working with the legal areas in Sweden and the Nordic countries that we have present here today come into contact with this area at some point. So you will, during this webinar, have the possibility to ask questions. You write them down using Mentimeter and the code that you see in the screen. We will, at the end, come back to the questions and take them in order that you have voted, because normally we get quite a lot of questions, so we have the possibility to vote so that we get the most popular ones first. Feel free to write them in English, but if you want, it is okay to write them in Swedish as well. I'll try to translate. But to help us with this area, we are so happy for our collaboration with Kilpatrick, Townsend and Stockton, and they have brought over a specialist from the US who work with these questions from the other side. So we are so keen and happy to have Amanda Witt here, partner at Kilpatrick and Townsend. Would you like to introduce yourself?
Great, thank you. Yes, my name is Amanda Witt. I'm a partner at Kilpatrick Townsend. I am the co-chair of our privacy, cybersecurity, and technology team. I have been practicing in privacy and data protection law since 2004, and I actually got my LLM in Leuven, Belgium, back in 2004, where I actually studied with one of the drafters of the directive. So I've actually, my first exposure to privacy law was actually GDPR. So,
so you've been there from the start.
Yeah, so I've been told I have a much more European perspective on privacy law than American perspective. So hopefully it won't seem so foreign to have an American attorney talking to the audience about GDPR.
We're so happy to have you here.
Great.
The stage is yours.
Great, thank you so much. Great, so thank you very much for the introduction. I really appreciate everybody who is attending today. So this is what we're going to cover, the roadmap here. So GDPR was adopted over 4 years ago, and it is absolutely transformed both American companies, but all global companies. We'll talk about how this specifically has impacted American companies first. We'll talk about the headaches posed by EU to US data transfers, which is very top of mind for everybody these days. We'll talk about the source of those headaches is the US national security laws. So we go into a little bit there to kind of explain what the issues are. We'll talk about GDPR enforcement trends as well, so you can kind of see what's generally what the regulators are doing with respect to enforcement. And then I will do my best to predict the future on transatlantic data transfers, but we do have some really interesting developments there as well. So first of all, GDPR had a huge impact on how American companies, but global companies generally, organize their privacy programs. If you think back before GDPR was enacted in 2016, you generally, you're lucky if you had maybe one privacy professional within a company. There really wasn't a well-developed privacy program within most organizations unless they were a regulated entity, such as a healthcare entity or a financial institution. But generally, there was not comprehensive privacy programs. There were not understanding of data flows. But GDPR, because it involves such extensive operational changes, so understanding all the types of personal data that you're collecting, all the legal bases for each processing activity, doing extensive data mapping, that and the fear of the fines. So the significant fines under GDPR, the maximum of 4% of global revenue or 20 million euros was unheard of for any privacy law at that time. So American companies really invested in complying with GDPR. They hired, dozens of privacy professionals. They worked with outside consultants and law firms, spent millions of dollars preparing for GDPR. And so now, especially for our clients that prepared for GDPR, they've been much better suited for, preparing for Brazil and for China and other comprehensive privacy laws. So it's really transformed what organizations do in terms of their privacy programs. And so now you see that, on average, American companies that are in the 25,000 to 75,000 range of employees, they have 13 full-time privacy professionals on staff and 33 part-time. They're investing over $873,000 a year in their privacy compliance efforts, which is an increase of 200,000 since 2020. And this is a survey from IPP that shows that there's tremendous investments in what U.S. companies are doing. And GDPR has really forced the U.S. to take action with respect to enacting its own comprehensive privacy laws. So although we don't have a federal privacy law just yet, we have California that's adopted a comprehensive privacy law. We have Utah, Colorado, Virginia, and Connecticut. And they are definitely influenced by GDPR, although they have some of the variations. But we're definitely seeing, and California, in fact, hopes to be declared adequate at some point, but I don't know if the EU is quite on board with that. So this is just showing you high level how some of the aspects of GDPR have been carried over into the U.S. comprehensive privacy law. So there's a very similar focus on data access rights, deletion rights, so the rights of the data subject. So you see that most of these laws have very similar rights to what you see for individuals under GDPR. And there's a little bit of a variation, which was introduced by California, this idea of do not sell. And so that's a little bit different, but there is generally a similarities, although there's a much less ability for individuals to enforce these laws. So California is the only state that has a private right of action, and that's only in the event of a security breach. So unlike under GDPR, where any individual can bring a claim, it's very restricted as to what individuals can do under these laws. They have to rely on the Attorney General or a privacy agency to enforce it. And just to show you that GDPR has also influenced other global laws, so the law in Brazil, the LGBT, followed GDPR very closely, and all of these laws, so both from GDPR to Brazil to China's law to the U.S. state laws, they have timing requirements with respect to responding to data subject rights. And so, although it's 1 month in GDPR, it's a much shorter time frame of 15 days in Brazil. It's a very uncertain amount on China. They basically use the vagueness to their advantage, unfortunately, and then it's 45 days in the U.S. states. So this is just an example of building blocks of a well-developed privacy program in the U.S. and I'm sure globally as well. So this is, for companies that have, very advanced data protection compliance programs, this is some of the core elements. And so it involves having, well-defined governance structures. So, have, privacy officers and ideally, privacy resources within each department. You have detailed data inventory, data mapping, understanding of the data flows throughout the organization. You do the training annually with employees, at least annually. You're operationalizing, so you're making sure that you're not just drafting policies, but you're actually implementing them. So these are data minimization, all kinds of principles that are carried out throughout the organization to protect data from throughout the entire life cycle. You're looking at data transfers. You're protecting the data from third-party vendors. Making sure that you have sound security in place. You are you're responding to data access requests. These are signs of a well-developed privacy program. And so this is a sample from one of my clients. It kind of shows you the hectic life of the average privacy professional. So she had so many things to do in a year. She didn't want to get behind schedule, so she basically created things that she wanted to do every month to keep on top of her privacy program. Whether it was updating privacy notices or updating training or sending out the updated notices to employees and doing the trainings to prepare for security breaches. So this is basically just an example of kind of how there's so much to do to comply with these laws that it's something you have to stay on top of for each month. So I assume the slides will be available, so hopefully this will be useful to some of you that are trying to keep up with compliance of multiple laws. So now the biggest headache that most of my clients are dealing with, and I'm sure many of you as well, is the challenges of getting personal data out of the EU to the US. And so just to recap, how we got here, we had, way back in the day, we had a thing called the Safe Harbor, which allowed data transfers from the EU to the US. And so in the Schrems 1 decision, that was invalidated. Max Schrems challenged it. And then we had Privacy Shield. And so then that was Schrems 2. So Max Schrems invalidated that as well before this. So the CJEU found that the Privacy Shield was invalid, even though that wasn't exactly the scope of the initial challenge of the case. But the main concern and the main reason why these frameworks were invalidated was a concern over the access by U.S. national security and intelligence agencies, and we'll get into that a little bit more. And this idea that it was a violation of the fundamental human rights and freedoms of Europeans to have their data reviewed without limits and not having adequate redress. So we'll get into some of that. But the problem was not only was Privacy Shield invalidated, which meant that U.S. companies could no longer, or even I guess you could have an EU company rely on as well. So companies could not rely on Privacy Shield to transfer data from the EU to the U.S. And then it also weakened the standard contractual clauses. So in terms of in terms of the data transfer mechanism of relying on standard contractual clauses or model clauses, previously you could just really just attach them as is to a contract and just rely on those. And so with what the CJEU said in its ruling in Schrems 2 was that the data exporter had a duty to really look at the country to where the data was being transferred and understand the national security laws in those countries to determine whether it was safe to transfer data to that organization. So kind of the level of effort that's required because of Schrems 2 was increased exponentially. So you had to basically do the model clauses, but then add supplementary measures and do transfer impact assessments. So it definitely the burden of doing transfers to the U.S. was increased significantly and globally, because it's not just the U.S. If you're transferring data to China or India or any country that's not adequate, you've got to go through that analysis. So obviously there was the challenges. Using the standard contractual clauses are much more difficult, and that's really, other than binding corporate rules and Article 49 derogations, that's really what most companies are using for data transfers right now are standard contractual clauses. So hopefully, we now have, after Schrems 2, the European Commission issued updated standard contractual clauses, and so that was helpful because they both updated the existing standard contractual clauses, or the model clauses, to reflect GDPR. They had previously referenced the directive. They also added additional modules. They addressed Schrems 2, so there's the idea of looking at the data practices of the country where you're exporting data. The modules were very helpful. So now you have the potential use of different modules for different types of transfers. So it's much more flexible than the prior standard contractual clauses. So if you have a controller to controller transfer, or you have a processor to controller, a controller to processor, or processor to subprocessor, you have much more flexibility in the new standard contractual clauses. I guess the challenge that probably many of you are dealing with is that you have to update. If you're still using the old standard contractual clauses, you have to have all of those updated by the end of this year. So by December 27th, 2022, you have to replace your existing, so the old SECs, by that deadline. So we have a number of clients that are very busy negotiating a number of DPAs every week. So also, because of Brexit, we don't have, they're not on the European standard contractual clauses anymore. They have developed their own. And so if you want to transfer data out of the UK to a country that's not adequate, so luckily the EU is adequate, so you don't have to worry about it. But if you were, transferring data from the UK to the US, they have an international data transfer agreement that is there, that can be used if there's data transfers that are coming both out of the EU and the UK. You can start with the EU standard contractual clauses and add the UK addendum. So that too has a deadline, but there's a little bit more time. So you have to update your UK standard contractual clauses by March 21st of 2024. So there's a little bit of time there, but the process is similar to updating your SECs. You need to identify, which contracts are using the prior SECs and get those updated. There doesn't seem to be so far a ton of negotiation on these, but there are certain elements where you might get some pushback on indemnities and choice of law and whatnot, at least under the standard contractual clauses. So generally, the new standard contractual clauses in the EU have a lot of benefits in terms of they contemplate adding new parties with a docking clause. So basically, say if you're using the standard contractual clauses to do an intra-group data transfer agreement, so allow data to be transferred amongst your affiliates worldwide. So say if you acquire a new affiliate, you can add that new affiliate using a docking clauses. There are onward transfers where you can basically, even if the controller is located outside of the EU, you can still use the standard contractual clauses as your data transfer mechanism. And then one of the modules issued by the European Commission is basically set up to be its own standalone data processing agreement in line with GDPR Article 28. So that's also very useful for companies that are still trying to comply with the GDPR requirements of having DPAs in place with their processors. There are some issues with the standard contractual clauses other than just the timing of getting them updated, is that the recitals, and they basically say that if you have a data importer, so an entity that's outside of the EU that is subject to GDPR, then you can't use the clauses. And so that's a real gap right now. The European Commission has promised that they will issue additional standard contractual clauses, but they haven't. So we have a number of our clients that are in this position of where they believe themselves to be subject to GDPR because they're targeting EU business, but they don't, their European business partners, obviously wouldn't like this either, but, not having the standard contractual clauses, as part of their agreement would make them feel that they weren't in compliance with GDPR. So we have this a little bit of a challenge right now where even though the new standard contractual clauses, they're saying that the standard contractual clauses should not be used for those types of transactions, that these we're still attaching them to our contracts just to make sure that they are, have some sort of compliant data transfer mechanism. So there is some uncertainty there. And there's also, obviously there's enhanced protections, especially around looking at, data transfers outside of, to countries that might have, security laws that are problematic. And another big hurdle is the joint and several liability in certain situations. And because the standard contractual clauses cannot be, contradicted or overridden by the underlying agreement, you might have certain liability caps in the underlying agreement, but then the joint and several liability provisions of the standard contractual clauses will control in the event of a conflict. And so that's definitely concerning for a lot of companies, is in certain situations they might have joint and several liability with the other party. So that's one area of concern. There's other issues that, there's data subject compensation that's called out. Specifically, there's data subjects have a right to receive copies of the standard contractual clauses. Obviously, with the UK having its own set of clauses, it's another challenge. And then, as I mentioned earlier, the burden of having to do a transfer impact assessment for each third-party country that's not adequate, where you're transferring data to, is a lot of work for companies as they try to get these in place. The European Data Protection Board has given guidance on putting the standard contractual clauses in place and getting the data transfer mechanisms, correct. They have issued these steps, and they've gone into sample supplementary measures, so you can kind of try to figure out what's expected, what extra steps need to be taken to make these data transfers compliant. And so it's generally helpful, but still. I'll dig into some of the areas that make it, that especially around the supplementary measures, that make it maybe not the most helpful guidance. So, and they give a couple examples of, what are some effective and ineffective supplementary measures. And so say if you're using a third-party company that's, based outside of the US, outside of the EU, and you're using them for data storage, it's just backup purposes, the vendor is not accessing data in the clear, that ideally the encryption key is left in Europe, and then so that the European Data Protection Board lays out 6 specific conditions to make this supplementary measure effective, and so that will work. That's a sufficient supplementary measure. But for most of our, technology and cloud-based, companies that we see, that's not typically the situation. Usually, if you are working with a cloud-based service provider where the data is being stored outside of the EU, or if you have, say, if you're even storing the data in the EU, but you have, remote access. So say you're, working with a vendor that needs, remote access to provide support. That remote access, to data stored in the EU is still considered a transfer. So you still have the data transfer issue. And then because the vendor is able to see the data in the clear and the vendor has access to the encryption key, because they can't provide support or they can't provide the services without having the encryption key, this is deemed to be insufficient. An insufficient supplementary measure. And so we'll see when we get into the Google Analytics cases a little bit, that this is, what a lot of the current U.S. transfers are, and there's a concern that these typical kind of cloud-based data transfers are unlawful under GDPR. So we'll get into that a little bit more. We see a lot of different risk management strategies from companies that are dealing with the challenges of transfers to the U.S. So there's definitely efforts to pseudonymize and anonymize the data more. So that, if you're only not transferring the the clear data outside of the EU, there's attempt to localize the data to work only with vendors that are in the EU, or partially localized. So we have a client where they store video data in the EU, and then the rest of the data is transferred outside of the EU. So there's different strategies there to try to show that you're taking some efforts to protect the data. There's also the Article 49 derogations, which could include consent, and so some limited options there, because you're not supposed to use them for repeated transfers. So it's not the best solution. And there's also, we'll get into it a little bit, the French regulator, the CNIL, has issued some guidance on using proxy servers and whatnot. So there's a variety of technical solutions, but given current trends, it seems like storing the data in the EU is probably the safest option, unfortunately, for a lot of companies. So the source of the concern is the U.S. national security laws. And so we'll get into the one that's probably you're most familiar with. So it's 702 of the Foreign Intelligence Surveillance Act. So it's called FISA 702. And so that basically allows U.S. intelligence agencies to collect data on non-U.S. persons who are located outside of the USA. And so those basically allow the government, it's usually a request that's initiated by the U.S. Attorney General and the Director of National Intelligence. That request is sent to the Foreign Intelligence Surveillance Court who will approve or deny the request. And then they basically can direct these requests to electronic communication service providers to get the information that they need. But they are, broad rights in terms of collecting information on Europeans and other non-U.S. persons. There's a broad interpretation of what an electronic communication service provider is. And so when you're doing your transfer impact analyses, that's kind of the first question that you're trying to figure out about the party that you're entering into a contract with. Are they an electronic communication service provider, or are any of their processors, do they fall into that category? And unfortunately, some of the guidance from the Department of Justice and some case law is basically, it could even be, a company that provides email to its employees, it could fall into that category. So it's a very broad definition. It picks up a lot of types of companies. And then so, the good news in terms of checks and balances is that the court that the Foreign Intelligence Surveillance Court, so FISC, they have, they, at least in the, as of 2020, they issued a report on how many of these requests they had approved and denied. And they, of 28 requests, they had 16 were granted, 10 were modified, and 2 were denied in part. So it's not, there were many concerns on the EU side that this court was just rubber stamping these and approving all of these requests. So there is considerable either modification or pushback on these requests. So it's not, I think, as broad as many companies had feared. And so in terms of the digging into what is an electronic communication service provider or a remote computing service, which is entities that are subject to this law to receiving these requests. As I mentioned, it can be very broad. And so some of the typical examples of an electronic communication service provider are, a telecommunications provider. So AT&T, Verizon, T-Mobile, those kinds of providers. So those you would definitely consider to be subject to receiving these requests. And they are the parties that are most often, most frequently receiving these types of requests. There's also a remote computing service. So if you have data stored with a vendor, whether it's AWS or Microsoft, Google, these would also be considered a remote computing service. And so those would likely be most likely to receive those requests. So there was a helpful expert opinion that was done in the last year or so for the benefit of the German regulators by a U.S. professor of Vladek on what are better understand. They wanted a better understanding of what these U.S. national security laws meant, and so it's written in a form of like question answer FAQ style. And so one of the questions was, if an entity, so if you're about to do business, enter into a contract with an entity who is not itself subject to FISA 702, but it's using a subprocessor that is, can the U.S. intelligence agencies gain access to, that data under FISA? And unfortunately, the question is answered yes. So basically, that's why as we get into the Google Analytics cases, is that there is a risk of, even if you are, the party you're entering into a contract might not be subject to these requests, their subprocessors could be. So the data ultimately, could be accessed by U.S. intelligence agencies, through use of those subprocessors. So it's definitely, something to consider when you're doing your transfer impact analyses. So let's talk about enforcement trends. And so the regulators have been very busy over the last 4 years, and unfortunately, American companies have been quite popular with the regulators, so especially the tech companies. And so we'll dig into, as you can see from this, this is as of September of this year, that you'll see quite a few of the U.S. technology companies have been fined quite a bit, and a number of times as well. And this doesn't even reflect some of the more recent fines, they're relating to children's data and whatnot, especially that were levied against TikTok. But digging into these fines a little bit, the largest fine was against Amazon. And it was curious, it was initiated first in France with the CNIL and then transferred to Amazon's lead supervisory authority in Luxembourg. And unfortunately, there hasn't been a lot of clarity about exactly the nature of the violations. All that's really been released thus far is that this relates to targeting of customers for advertising purposes without their consent. And so that's what the Amazon fine of $888 million was. And so one of the decisions that came out shortly after Schrems 2 was out of Portugal's regulator. So they suspended data transfers to U.S. company Cloudflare because there was concern about access by U.S. intelligence agencies under FISA. So that was specifically related to government access in light of Schrems 2. And then there's just a number of other technology companies that have been fined for a number of reasons, and including Google being fined and investigated by the Swedish DPA about the right to be forgotten. And I've heard that the Danish regulatory actions against using Google Chromebooks in schools has also been a concern. So definitely, Google and Facebook and they've both been very, very busy in the EU with respect to the enforcement actions that they've been dealing with. There have been some trends. I mean, definitely, it took a little while for the regulators to build up steam and start enforcing GDPR. It was, it required, GDPR required a massive investment from companies, but also from regulators. They had to hire staff and also train their staff and get ready for and these enforcements have taken years of work to get in place. And so now we're seeing since 2019, in 2020, a significant jump in enforcement, and we've seen a lot of activity this year. And we've seen some of the largest fines. The Schrems 2 fallout we'll get into a little bit as well. But the trends are definitely, there's a number of regulators that have taken action with respect to children's personal data. That's in the U.S. as well. We're seeing a lot of activity, regulatory activity with respect to children's data. There's also been a lot of targeting advertising and marketing violations. So for sending unsolicited emails or doing unsolicited marketing calls, those have actively been enforced by regulators. Also security breaches. So, once you have to report a security breach to a regulator, it seems that investigations start and then, fines often are issued, or, some kind of enforcement are issued after that. And unlawful surveillance. So, using cameras and whatnot, those have been areas of a number of areas that had regulators enforce that. There's been some curious outcomes, especially in the UK, where they will issue a large fine and then it will be negotiated down and they'll reduce the fine. So that happened with British Airways, for example. So there have been some instances where the initial fine has been higher, but then it has been reduced over time. So that's been interesting as well. So I've referenced the Google Analytics cases are really probably some of the most concerning cases for anybody worried about EU data transfers. And so for those of you who don't know, Google Analytics is just something that most websites use to understand how their websites are being used. So it tracks, what is a user doing on a website? Which pages are they using the most? Like, where are they likely to enter information? They're really not, it's not intended to collect detailed personal data, but it is picking up IP address and device ID. So it's clearly personal data under GDPR, but it's not very sensitive. And according to Google, the US government has never requested this type of data under a FISA request. So it's very, from Google's perspective, it's very low risk data because it's not likely to be requested by the US intelligence services. There's, other types of data that would be much more interesting. But unfortunately, we've seen a number of European regulators saying that using Google Analytics constitutes an unlawful transfer under GDPR. So it first started with the Austrian regulator basically saying earlier this year that using Google Analytics was unlawful. And what these cases all started out of complaints being filed by Max Schrems' organization and NOYB. And so that we're having very similar findings from regulators based on kind of all these complaints that were very similar. So the French regulator, CNIL, followed that and then also gave a little bit more information on why it was unlawful and what are some measures you could potentially take. Italy's regulator recently found using Google Analytics is an unlawful transfer, and most recently, the Danish DPA also found them to be unlawful. So basically, they're advising companies, to not use Google Analytics because they believe it's an unlawful transfer to the U.S. So there are a lot of companies that are removing Google Analytics from their websites. So they're trying to change to providers that are based in the EU. They're maybe waiting to see if their particular regulator takes action. So there's definitely a lot of uncertainty as to what to do if you are using Google Analytics. And as I mentioned, the French regulator really gave some very helpful guidance on what to do if you are using Google Analytics. So instead, they do consider it to be unlawful transfer because Google is an electronic communication service provider that is subject to FISA requests. So even though the government hasn't requested this type of data before, there's a concern that they could have to give that data over. And then even though Google has, says they have a variety of settings to make these transfers lawful, the French regulator said that those are insufficient. And encryption might work, but they suggested that the best solution was implementing a proxy server, which is a technical option, but it's highly technical and expensive to implement. So it may not be the best solution for smaller to mid-sized companies. And explicit consent doesn't cure it, so you can't have the data subject give explicit consent to agree to this. And then if you're doing your transfer impact analysis, there's basically no way to solve this issue. So that's definitely a problem. And so with the trend that we're seeing with especially these Google Analytics cases, it's really looking very difficult to lawfully transfer personal data from the EU to the US. And so many privacy professionals are just very concerned and very worried. So there seems to be one possible solution. So this is a rather exciting development that's come up where we, earlier this year, it was announced that the White House and the European Commission had come up with a agreement in principle, and so we actually saw now we have an executive order issued from the White House that basically outlines the new transatlantic data transfer framework. So it will essentially replace the Privacy Shield, and so this will allow companies to transfer data from the EU to the US. And so it's a two-part. So we've got two parts of it that have been issued so far, where it's both the executive order that comes from President Biden, the White House, and then it also the Department of Justice, the DOJ, has issued regulations that set up this data protection review court that I'll discuss a little bit further. But it's basically the executive order and the Department of Justice regulations clearly address the concerns raised by Schrems II. And so the next step in the process is that the European Commission will review it. They will get feedback from the European Data Protection Board. They will also get input from the European Parliament potentially, and then they will basically, the goal is for the European Commission to declare it adequate. And then we're hoping that that would happen, probably the earliest would be March of 2023, but it might not be, maybe a few months later, but there's definitely hope that this would be in place by next year. Definitely so the way that it's going to work, so it basically, the concerns raised by Schrems II basically was that, the access by U.S. intelligence agencies, there was, a lack of necessity and proportionality that limited U.S. surveillance programs, and there was insufficient redress rights. So if a data subject had their data accessed, they did not have adequate means to object to that processing or have any kind of redress from the U.S. government. So the executive order and the Department of Justice regulations address these shortcomings head on. And so it will be structured in a way that's similar to Privacy Shield, where a U.S. company or any company that wants to certify, they self-certify to it, because the Privacy Shield principles were not at issue in Schrems II. They're basically going to leave the Privacy Shield principles in place for the most part, but update them for GDPR and do a couple of minor updates. But the process to self-certify into this new framework will be the same. The executive order limits U.S. intelligence authorities. It limits the U.S. signals intelligence activities to what is necessary and proportionate. So for years, as the U.S. and EU have negotiated both Safe Harbor and Privacy Shield, the U.S. objected to these terms specifically. So it's a huge deal that the U.S. has finally agreed to these terms. Problem is that it's or not problem, but I guess the difference is that the U.S. has defined what those terms mean in the executive order, which it seems to be very reasonable interpretations of them. But there's the concern that it's not as the EU defines them. The reason it was not defined as the EU defines these terms is because those definitions have changed over time as we get additional cases out of the Court of Justice of the EU and the Court of Human Rights in Europe. So there was a desire by the U.S. to have certainty as to what these terms mean. So that's one element of difference. It also identifies 12 legitimate objectives that will allow the processing of this data under these laws. So it really limits to what type of activities are permitted, and then it also has 4 prohibited activities. And so that's one of them being suppressing or burdening criticism, dissent, or the free expression of ideas or political opinions. So that's really important, and it's a very public and enforced limitation against that there's probably very few global intelligence agencies that have been subjected to such limitations. So there's really this is probably the farthest that the U.S. government could go on these, and they've also, the way that they've outlined what the kind of the process here and the framework, they've tried to track it very closely to what EU intelligence agencies are doing, because the goal here is for essential equivalence between what the US and the EU is doing with respect to intelligence services. And one of the really interesting areas that this new framework goes in terms of achieving the issue about redress is there's now a 2-step redress process. So first of all, there's the Department of Justice regulations have created what's called a data protection review court. And so it will be basically under the executive branch. And so there was some some concern raised that the executive order is not an actual law, and that this data protection review court, a law passed by Congress in terms of, instead of passed by the president, and that the data protection review court is not under what we call Article 3 courts, so, under the judiciary branch. So the reason that everything has been structured this way is that the reason it's an executive order is because the executive, the president, has control over U.S. intelligence services. So they are the executive is in the best position to put limitations on these organizations. It's also possible if Congress wants to enact legislation kind of codifying this, that's definitely possible. But even if there's a change in president, it's very unlikely that they're going to want to do anything to upset the possibility of EU data transfers. It's such a huge source of revenue for both regions. So it seems very unlikely that subsequent presidents are going to repeal this executive order. And then the reason that there is a court that's under the executive branch is that in the U.S., under the Article 3 courts, you need to have standing. And so if you're not a citizen of the U.S., and if there's no, it's very hard to prove privacy harms to give you standing in the court generally. You usually have to have some kind of financial harm, but there's a lot of hurdles to getting into a U.S. court. So this is setting the court up this way is the best way to give redress to EU citizens that have been harmed by this access. And then it's also the way the framework is only available to qualifying states. And so this court, although the executive order and the Department of Justice regulations are effective now, this court will not be available to EU citizens until the Department of Justice says that the EU is a qualifying state. And so that will be somewhat based on whether the EU or the country's surveillance authorities have similar restrictions to what this executive order puts in place, and then whether data transfers remain possible between those two regions or countries. So definitely, we want to see reciprocity in terms of if we're, agreeing to limit our U.S. intelligence authorities in this way, we want similar protections for U.S. citizens as well as under those laws. So in terms of the two-step redress process, so if you have a data subject in the EU that wants to complain about these practices, they first go to the regulator. So say if you would go to if you're in Sweden, you would go to the Swedish regulator and make a complaint. And if it's a qualifying complaint, then the regulator will communicate that complaint to the Director of National Intelligence's Civil Liberties Protection Officer, and they will investigate it. And there are protections in place that require both the independence and protection of that officer from being fired. It requires the intelligence agencies to actually cooperate both in the investigation and enforcing any changes that the CLPO recommends. And then so if at that point, if the complainant is not happy with the findings of the CLPO, they can appeal to the Data Protection Review Court. And so at that point, and also the intelligence authorities can also appeal. But ultimately it is, and that the court is made up of individuals that are not U.S. government employees. They are, ideally half of them have a pool of 6 possible judges. Half of them have to be, have judicial experience, and then it's very difficult to fire them. It's basically only for cause. So there's this idea that this is an independent review process and redress process, and they are protected from the intelligence authorities trying to take adverse action against them. So they believe that this redress mechanism will satisfy the concerns raised by Schrems 2. So the only issue, obviously, is that Max Schrems has already issued his concerns that this mechanism is not what the Court of Justice of the European Union wanted, that there is a problem, that it's not a law and just an executive order, and that there's differences in the way that necessity and proportionality are defined. And so there's definitely many who expect that this will be challenged, but based on my personal opinion, and I think that this is exactly what the Court of Justice of the European Union was asking for to get to essential equivalence, and it's very much in line, even though bulk collection is still allowed. and the response on what we can disclose to the individual about the investigation. It's very consistent with what EU authorities are doing as well. So we have hope that this will actually be something that will hopefully solve the data transfer problems. But I'd be happy to address any questions if there are any.
Okay. Wow, Amanda.
A lot to cover, I know.
A lot to cover, but you did it so well. In 45 minutes, you've given us so much light on these areas and questions. And we have had a lot of questions rolling in. So I would say also to you listening here, the webinar will remain active, so you can access it on our website. You can share it with colleagues who have not been able to participate, and of course come in with questions afterwards. There have been a lot of questions, so good that you have voted. We'll take them in that order, and I'll also say that we will try to collect them afterwards. Anyone present will have the opportunity to test ITNet, our web-based service, covering this area, and often we try to respond to the questions in there as well and see if we can get some help from Amanda perhaps in there as well if there's any open. But let's go on to the questions then. We'll start with the first ones.
Great.
Okay. Does a third country transfer which actualizes the Cloud Act and can allow US authorities to access data from the EU mean that the transfer is illegal under the GDPR?
And there's definitely a concern. I think the Court of Justice, the EU, and a regulator has not specifically issued guidance onto whether the Cloud Act violates GDPR. But basically the Cloud Act came out of where Microsoft specifically was requested to provide data in connection with litigation in the US, and they fought that request all the way up to the Supreme Court. And so basically, that Microsoft's argument was providing that data would violate GDPR. So there was definitely a concern underlying, why that request was initially resisted, but basically the Cloud Act was passed to require Microsoft to cooperate and provide that data. So I think it's a real conundrum for a lot of U.S. companies or any company that's subject to both of these laws. So it's basically, do you comply with the Cloud Act and comply with U.S. law, and potentially violate EU law, or are you going to comply with EU law and potentially violate U.S. law? So it's most for Microsoft and others, like they've had to take complying with the Cloud Act. But we haven't seen it tested in the EU yet. So I would be very curious to see whether we see a regulator or CJU, but it's a relatively recently effective, so we haven't seen a challenge on that yet, but definitely a concern. So it's definitely, as part of doing the transfer impact analysis, that's definitely a law that has to be mentioned, and you have to kind of analyze the risk of the data transfers being required for that particular law.
Okay, Google, Microsoft, and Amazon often presents that they are frequently asked to give out data. They say that they don't do it. Can we be safe with that answer?
Well, they do their best to not do it. A lot of the larger technology companies, and especially these particular companies, they issue transparency reports. And so they tell you how many of these, how many of these requests they comply with. The problem with the U.S. National security laws is a lot of times, especially the national security requests, they require confidentiality. So that the company cannot tell the data subject that their data has been requested, and they can't tell the European counterparty to the agreement that this has been requested. All they can do is release the kind of range of requests they've gotten. So you see, in their disclosures, they'll say we've complied with between 0 and 499 of these requests. And so that's, they will tell you that they've had to comply, but they can't tell you specifically that it was related to your data. So yes, it's definitely, it was admirable, especially like Microsoft, especially went very far to fight these requests. But it's U.S. courts, unfortunately, are hesitant to pick foreign law over complying with U.S. law. So most of the time in litigation in the U.S., when forced to choose between complying with the U.S. law or GDPR, they're picking the U.S. law. So most U.S. companies that end up in litigation, or if they get one of these requests, if it's a lawful request, it's very difficult for them to turn down. So.
Mm-hmm. Good questions. Okay, so a question in Swedish. Do you believe EU will find that the US have an adequate level of defense? And would we here dare to be a little bit cool and not update your SECs and rather do processor contracts?
Yeah, so two parts to that question. So there is definitely there's definitely an expectation that the European Commission has been working very, very closely with the U.S. on the new transatlantic data transfer framework. So there is definitely an expectation that the European Commission will issue an adequacy finding. So we'll find, at least for organizations that are using the new framework, which is like Privacy Shield, that the U.S. will be deemed adequate for those transfers. The question is, as a Privacy Shield and Safe Harbor, will the Court of Justice of the EU actually agree with that? So that's the concern. And I think, just in my personal opinion, it's really hard to predict. But based on what, the limitations that have been put in place on U.S. intelligence authorities is much farther than they've ever gone before. And, probably farther than any European surveillance or intelligence agency would maybe be publicly willing to admit either. And then the two-step redress mechanism is definitely, it's gone, it's meant to address all the issues that were raised in Schrems 2. So I definitely think there's a good chance that we'll at least have adequacy maybe for a few years and until it's challenged, and then we'll see how it survives a challenge. But yeah, no, I think in terms of updating the standard contractual clauses by the deadline, I think it's ideally it would be great if you could, but most of our clients haven't gotten to we're 100% updated or even having sent out any other updates at this point. I think there will be a lot of negotiations that are happening, both to the end of the year and early next year. I think it's a very time-consuming process, and the good news about the regulators are very busy, and they're under-resourced and under-budgeted. So I don't think that there's going to be a lot of regulatory interest in going out and auditing compliance with these. So I do think there's a little bit of a cushion, not to completely panic, but it is something to get in place. And it's interesting with the as part of the U.S. laws, there are contractual updates that need to be made, and the California Attorney General has looked at whether those updates have been made under California law, and has, in one of the recent fines of Sephora, basically cited the failure to update those contracts. So we've had actual U.S. enforcement of those kinds of updates before we've seen EU enforcement. So I haven't really seen. There's no need to lose sleep over that right now, but definitely work on getting them updated.
Okay, good questions. Go on to the next one. We have time for one or two more. Your view on the new executive orders effect on the TIs you need to do when you rely on the SECs or BCRs as transfer mechanism?
Okay, that's a really great question. I forgot to raise it. So the really great news about the executive order and the Department of Justice regulations, so they are effective. They are existing law right now. And so when you're doing your transfer impact analyses, you can include the new limitations of necessity and proportionality on the U.S. intelligence agencies in your TIAs. So that's effective now. Those are obligations that start right away, which is great. In terms of, you can't rely on the two-step redress mechanism, so the Data Protection Review Court, until the Department of Justice names the EU as a qualifying state. So now we're looking at whether I think the Department of Justice is currently looking into whether the EU, or it could be an individual country, it doesn't have to be just the EU, it could be a region or a country, has similar protections in place for U.S. citizens, and whether data transfers are likely to continue. So that's kind of the next step in the process, to wait to hear whether the EU is considered a state or region that can take advantage of this new mechanism. But it's very helpful that we have those new limitations for the TIAs.
Good. Okay. Regarding Google Analytics, I read an article stating that you can choose to have all data stored in the EU. Do you know if this is an option?
So the French regulator said that Google had implemented certain measures. I think the Danish regulator addressed those too. They think that those storing data in the EU doesn't solve the issue because it can still be accessed by the US entity outside of the EU. So unfortunately, because you have access constituting a data transfer, it doesn't quite get you there. And so that's why there's been a concern generally that relying on Google, even if they're saying they put protections in place, doesn't fully solve the problem. But there's some very curious aspects. So I think a lot of companies now are selling, it's like a marketing advantage to basically say like all of your data will be stored in the EU, but then they forget that if there's so we entered in recently, we're negotiating an agreement with a company based in Israel who was saying that they were storing all the data in Germany, but then our company was accessing it in the US. So I was like, well, that's a transfer, and they're like, no, all the data stays in the EU. Like it doesn't. Like if it's being accessed in the US, it's still a transfer. So yeah, so I think it's not that argument has not impressed the regulators, unfortunately. So yeah, it's still a problem.
Good clarification. Okay, I think it will be probably the last question coming up. Do you believe that it is helpful for companies transferring data to the US, that is by using US cloud providers to perform TIs, etc., and thus be as compliant as possible under the current circumstances?
Yes, definitely. I think, given the guidance, both from what we're seeing from regulators, also out of the European Data Protection Board, and even the Schrems II decision, and what the new standard contractual clauses say, they basically require you to represent that you've looked into the laws of that country where you're transferring the data to. And so a regulator could come in and look at that particular section and say, okay, where is your documentation? So you need to have the TIAs in place just to show that you've gone through this analysis. Even I know that there's either, given some of the recent guidance, it feels like it's not permissible to ever transfer data to the US. But, I think that it helps, at least that you show the regulator that you did the analysis, you put measures in place to restrict this access. Because most companies have not gotten these requests, most US companies have not. And so if you can kind of show that you've done your homework, it will definitely help, give comfort to the regulator that you're aware of these issues and you've addressed these issues. And so it'd be much less likely to get fined or have an enforcement if you have these in place. And so definitely I recommend getting those in place as soon as possible. And it's also, say if you have you're working with a service provider that's based in, processor that's based in the US, but then they're transferring data to India or to Costa Rica or Guatemala, like to third-party countries, you have to look at the laws of those countries as well. So it can be a lot of documentation that has to be put in place, unfortunately, especially looking at, their subprocessor. So it's, but I think doing at least doing the initial, like if, you've got a processor based in the US, at least having, that initial analysis done will definitely help in terms of making the regulators happy that you're aware of these issues. So
it seems difficult to comply.
Yes. Lots of documentation required.
So we've run out of time. Thank you so much, Amanda, for coming here, giving us light on the area and answering all these questions. The webinar is active, so please feel free to share it. Please take the opportunity to test ITnet, where you can dig in further to the area and continue asking questions. And hopefully we'll meet again here with Amanda, perhaps again in further subjects. Thank you so much and have a nice day, everyone.
Behöver er verksamhet stöd av en juridisk rådgivare? Vi hjälper gärna till. Läs mer på jpinfonet.se.